Hello and welcome. Today we're jumping right into the essentials of partnership law, straight from Title IX of the Civil Code of the Philippines. We're going to break down this super common business structure by following its entire life story, from the moment it's created to the day it ends. This is a must-know for any law student or aspiring entrepreneur out there.
So here's our roadmap. We're going to start with the basics. What a partnership even is. Then we'll look at all the different forms they can take, the rules that partners have to live by, and how the law sees a partnership as its own person. After that, we'll cover how they end, and finally, we'll put it head-to-head with a corporation. Let's get started with its birth.
All right, first things first, the birth of a partnership. What does it actually take to create one in the eyes of the law? We're about to cover the official legal definition and the absolute non-negotiables you need for a partnership to even exist. Article 1767 of the Civil Code gives us the exact recipe. It all starts with a contract. That just means there has to be an agreement. Then every other piece is just as important. You need two or more persons who agree to contribute something. That could be cash, a piece of land, or even just their skills and hard work, which the law calls industry. All of that goes into a common fund. And, this is key, the whole point, the ultimate goal, has to be dividing the profits. That profit motive is what legally separates a business partnership from, say, a nonprofit club.
So, let's boil it down. For a partnership to be real in the eyes of the law, you need these four things, all at the same time. You need a contract that comes from consent, a real contribution to the pot, the clear goal of making and splitting profits, and, of course, the business has to be for a lawful purpose. You miss even one of these, and legally speaking, it's not a partnership.
This brings us to a really core idea that's all about trust, delictus personae. It's Latin for choice of persons, and it means a partnership is deeply personal. You have the absolute right to pick and choose who you go into business with. This is exactly why a partner can't just sell their share to some random person and make them a new partner. No, the other partners have to agree because they're putting their money and their reputation on the line with this person.
Okay, so we know how a partnership is born, but what do they look like? Well, they actually come in a few different flavors. The law sorts them out based on what they do, how long they'll last, and, most importantly, how much risk the partners are taking on.
First, let's look at their purpose. A universal partnership is the all-in version. It could be where partners throw in everything they own, or it could be a partnership of all profits they make from anything. It's broad. On the flip side, a particular partnership is laser-focused. It's set up for one specific project, like building one particular condo, or two lawyers teaming up for just one court case.
Now pay close attention, because this one is a huge deal for your personal finances: liability. In a general partnership, if the business can't pay its debts, the creditors can come after the partner's personal stuff. Your house, your car, it could all be on the line. But a limited partnership creates a shield. It allows for limited partners who can only lose what they invested. Their personal assets are safe. The catch? The firm still has to have at least one general partner who carries all that unlimited risk. So, the partnership is formed, and we know what kind it is. Now we get into its day-to-day life. The relationship between partners isn't just the casual handshake, it's run by a strict set of legal duties and rights that are all about keeping things fair and honest. The absolute #1 rule is what's called fiduciary duty. It's a fancy legal term, but the idea is simple. You have to act in the best interest of the partnership, period. It means you're held to the highest standard of trust. You need total good faith, loyalty, and honesty. In plain English, the partnership always comes before your own personal gain.
And that big idea of fiduciary duty breaks down into some specific jobs. You have to put in what you promised, and on time. Under Article 1789, if you're an industrial partner, the one contributing your work, you usually can't run another business for yourself on the side. That's to avoid any conflict of interest. You also have to give back any secret profits you made using the partnership's resources. And hey, unless someone is officially named the boss, every partner gets a say in how the business is run.
Okay, next up is a legal concept that might bend your brain a little at first, but it's crucial. From the second it's created, the law treats a partnership as its own person, totally separate from the partners themselves.
Article 1768 is where the magic happens. It gives the partnership a juridical personality. What does that mean? It means the partnership can own property, get into debt, sue someone, and get sued, all under its own name. And the Supreme Court has been really clear about this. This separate identity pops into existence the moment the partners agree, even if they forget to do all the official paperwork.
This right here shows you what that separate personality means in the real world. That office building owned by the Santos and Reyes law firm,
It belongs to the partnership entity, not to Mr. Santos and Ms. Reyes as individuals. This legal wall is super important for keeping business assets safe from a partner's personal debts, and the other way around.
Well, nothing lasts forever, and that includes partnerships. When it's time to close up shop, there's a formal two-step process the law requires. First comes dissolution, and that's followed by winding up. Now, it's really important to get this straight. Dissolution is not the end, it's the start of the end. It's that moment when the relationship between the partners fundamentally changes. Maybe someone retires or passes away, or the project they started is finally finished. The partnership as an entity actually keeps existing for a little while longer, but for one reason only, to wind up its business.
So, during that winding up phase, you can't just hand out the money however you want. Article 1839 of the Civil Code lays out a strict pecking order. First, and most importantly, you have to pay off anyone outside the partnership, your suppliers, the landlord, the bank. Second, you pay back any partners who loaned the business extra money. Third, the partners get their original investments back. Only after all of that is settled, if there's anything left, do you get to split the profits.
All right, for our final section, let's put all this into perspective. We're going to compare the partnership to the other big player in the business world, the corporation. Deciding between these two is one of the first and biggest choices any founder has to make. So, this is the million-dollar question for any founder, right? You're at a fork in the road, deciding how to structure your new venture. So how does a partnership really stack up against a corporation? Let's break it down. This table lays it all out. Partnerships are way easier to create. You just need an agreement. Corporations are creatures of the law. You have to go through a formal registration process with the SEC. But the biggest difference, the one you really need to remember, is liability. General partners have unlimited personal liability. Stockholders, on the other hand, can only lose what they invested. Management is also more hands-on in a partnership versus the formal board of directors in a corporation. And remember delectus persona. That's why you need everyone's permission to transfer your interest in a partnership, unlike corporate shares, which you can usually sell to anyone you want. So let's wrap it all up with the life cycle we've just walked through. A partnership is born from a simple contract, built on trust and a common goal. Its life is guided by that high standard of fiduciary duty. As an entity, it exists as its own legal person, separate from its owners. And its death follows a clear, orderly legal path of dissolution and winding up to make sure everyone gets what they're owed.
And that brings us to our final thought. A partnership is all about personal trust and direct control. It's simple to start, but it asks for huge personal responsibility. So the real question to think about is this. For what kind of business, the kind that's built on a tight-knit professional relationship, is this unique legal structure not just a good choice, but the absolute perfect fit?